let's get started. Okay, hello everyone and welcome back. It's only been like 2 minutes since I spoke with you last, but welcome anyway. Again, my name is Bree Bantil. I'm the Director of Education for Alt Legal and your Master of Ceremonies. I'm also the person who is here to make your experience amazing, so let me know how I can do that. If you do have any feedback for us, just a reminder, we would love to have you put that in the feedback form just on the right of this page. Tab over from where you would chat to put in that feedback. We would love to have it. As a reminder, while we're looking here at the code of conduct, I guess has been removed, but just a reminder, please don't be a jerk. That's all. We're going to ask you to leave. We won't give you a refund. It's going to be terrible. Don't do it. So I don't anticipate that you will be. All right. Do you want to talk just a little bit about CLE? We are offering CLE credit for this session through the state of California. You will need to, first of all, you must attend this session live. If you're watching this via recording, you're still going to learn a ton, but we're not able to provide you with a certificate of attendance or otherwise help you get CLE credit in your state. You must be present for the entire time. That is 70 minutes, 70. Please make sure to write down the code, which I will come in and say to you. Write it down. Don't plan on memorizing it, please. It will need to be exact. It will not have any spaces. We will send a survey at the end of the session. Make sure to put the code in the survey and submit that survey, and then you should get your certificate of attendance. This should go without saying, but Alt Legal is a legal technology company. We're not a law firm. Nothing that's said here should be considered legal advice. And the upcoming presentation expresses Lydia's views, and I'm sure they're wonderful and great views, but they may not necessarily be the same as Alt Legal's views. So please do use the chat to talk amongst yourselves and to share any resources. If you have questions for Lydia, go ahead and put those in the chat. But if you start them with the word question, that'll help our team know what to get over to her. So somebody from Alt Legal will then check that and make sure that Lydia gets those questions. So I am incredibly pleased to welcome our speaker, Lydia Govina. She's a partner at Frost, Zelnick, Lehrman, and Zissou, where she focuses on international IP rights. She's been recognized by World Trademark Review as a global leader in trademarks. And honestly, if I listed off all of her awards and recognition, I'm pretty sure she wouldn't have any time to speak left. So I won't do that. I just want to hear her wonderful presentation. Here's Lydia.
Hi, everyone. Thank you so much, Bree. I really appreciate those kind words. My name is Lydia Gabetta, and I'm going to be talking to you about traversing the universe of global trademark protection. With Alt Legal, here's my disclaimer page. This is not going to be legal advice, and so basically, I'm just giving you my opinions or my perspective from having practiced in this area from a number of years. So please use this for your entertainment and information purposes only. So I'd like to start off with just sort of generally why IP regulations are important to brand owners. For most companies, IP is core to their business. The benefits of the stronger IP protection can include helping promote economic development and growth, both for larger and smaller companies. It can discourage rampant piracy or infringement, prevent dangerous counterfeit products from entering into the marketplace, so there's a consumer safety issue. And it also provides brand owners with a level of assurance that they have the appropriate recourses to pursue infringers. And so over the course of the next hour, I'm going to be talking to you about differences between the US and various countries on the protection of brands, the enforcement of brands, and also using treaties to your advantage. So with that, I will start. So in the United States, It's important to understand that registration is not required to acquire trademark rights. Use will create those rights. So, basically, and we'll see this in the next slide, you can begin to use your mark and you will develop those trademark rights as a part of that. For US entities, you can seek registration based on proposed use. However, in order to secure the registration, you will ultimately need to provide specimens of use, and you must demonstrate that to the USPTO. Foreign entities can seek registration based on proposed use and prove use, just like US entities. Alternatively, they can rely on their home country registration without providing use in the first instance, though ultimately they will need to do so. Outside of the US, generally speaking, it's really important to secure a trademark registration. And this is why I think when you're working with your clients, you really need to advise them to think ahead of the game. Because if you don't secure those registrations, it can be a problem down the line. It's also important to understand that use generally does not create rights. So, unless it's a well known or famous trademark, which can be an expensive endeavor to demonstrate that you've acquired those rights, it's really important to think about registering in the first instance. And it's also important to be able to um, secure rights in order to be able to use your mark in those jurisdictions. So, why register? In a majority of jurisdictions outside of the US, the only way to effectively create rights is to secure a trademark registration. It's evidence of ownership and validity. It also provides constructive notice to infringers because your mark will be on the relevant trademark office's register. So people can't really say, especially if they filed applications and registrations on their own, that they were unaware of your rights. It also can act as a deterrent. By having that registration on the USPTO or other trademark office databases, it warns others that you are claiming rights in that particular mark. Also, once you have that registration, especially in countries outside of the US, having that piece of paper to wave at other people can prevent potential objections to use and or registration. So if you're a US company or you're a company based in another jurisdiction, why should you care about foreign trademark laws? Well, I think one of the reasons why you should care is that the world is becoming increasingly international. The way that brands promote their trademarks across different social media and on the internet means that your brand is out there, and it's important to think about your portfolio in order to make sure that you're adequately protected. An innocent party, for example, not even an infringer, could register your mark in a jurisdiction where the rights are based on registration. And even if you started to use in the United States, if you haven't used in that jurisdiction, that third party's mark could be an absolute block to entering into the marketplace. So you may be prevented from selling or even advertising in that jurisdiction. Another thing is the pirates monitor both the US PTO as well as social media pages, etc., and then they seek to register infringing marks on the trademark office databases of other or data trademark offices of other countries. So if they get them first, again, you could be blocked. Also, and as I said in the beginning when I was talking about the importance of foreign laws, social media has significantly increased the potential for cross-border piracy and confusion. So again, it's really important to get ahead of the curve when you're trying to protect your rights. So I want to talk just sort of briefly on searching. Um, so basically, there's a couple of different ways of searching for the availability of trademarks. You can do a database knockout where you will look for identical marks. Sometimes, depending on your algorithm, you may be able to catch some similar marks. But the point of a database knockout search is to try to find the obvious red flags. Also, for if a client doesn't have a huge budget, this may be the only thing that they can sort of afford, though it's not ideal, obviously. Another level of searching would be a full trademark availability search, and this is useful in countries where use alone can create rights, um, including the UK and Australia and others. Or if you're going into China or Korea where a foreign language and characters are used and it's not so easy to search them on a your standard database. Both with database knockout searches and full ability searches, use investigations are important, particularly if you see potential obstacles that may be older and you may not be aware of whether the mark is actually in use because you've done an internet search. So in those instances, in both of those, oftentimes when you do the searches, you want to make sure that you follow up with investigations because things may be considered a block initially, end up not being as serious a risk. Additionally, well, once you've done these searches, it's always important to sort of think about filing a trademark application, at least in one country of the Paris Convention, member state of the Paris Convention, before you announce the name. And the reason for that is that you don't want to announce the name and not have filed and then run into the problems that I briefly discussed previously. So, some unique things to searching when you're searching as a US company in other jurisdictions or even in your own jurisdiction is there could be unanticipated meetings for trademarks. So sometimes it's important to do these sort of full searches because you may come up with a trademark that you think is a wonderful thing, but then realize that it might be offensive or it might have a different meaning in a particular country. So just because you think one mark will work everywhere else, it may not be the case. So as I said, just now, that no mark is likely to be declared everywhere. So what if the mark's not available? Well, one thing you can consider, particularly for older marks that are vulnerable to non-use attacks, you could consider possibly acquiring those rights. You might want to do it as your client, or where it's available, you may consider having your local counsel, if they're able to do it anonymously, acquiring that right on your behalf without the third party knowing, because oftentimes that may be less expensive. You could consider consents or coexistence agreements. Of course, you want to be careful about how you approach third parties for consents because you want to make it clear that you don't think that the marks are confusingly similar, but or if you enter into a coexistence agreement, inevitably you may be giving up something that you might not want to. So it's just important to think about whether that's the option that will be best for your client. Another approach you could take is adopting a different mark. There are countries or companies that have done this previously. One example, for example, in the US, you have the TJ Maxx store that operates under the TJ mark, whereas in Europe and Australia, they operate as TK Maxx. So sometimes you may be able to make slight modifications in order to avoid any potential issues. Sometimes it may be an altogether different mark depending on the level of risk assessed or and the particular jurisdiction. Another way of differentiating your mark is to consider adopting the mark with your house mark, especially if your house mark is well known, because then if someone were to try to object to your rights, you could say, well, look, my house mark is well known, and so everyone will automatically associate it with me, and there's no likelihood of confusion. And sometimes if you have sort of a design mark, depending again on the jurisdictions, because there are varying levels of protection, you could consider copyright or design patent protection. Of course, with design patent or industrial design, as it's called in certain jurisdictions, it has to be novel. So you really have a small window of time in order to file the subsequent application. So now let's sort of turn to filing differences. So, I touched upon this briefly. In the US, you can file based on use and commerce. You will have to provide a specimen. And just be careful to know that you really have to provide an accurate specimen and make sure that when you're claiming use in commerce in the United States, that you are actually in fact using the mark for all the goods and services in which you're claiming use. Because the USPTO has started an audit program and they will look at this very carefully, even after your mark is registered. So it's just important to understand that. You will also need to provide a date of first use. You can also file based on intent to use, but you would have to have a bona fide intention to use. So it is key to make sure that it's not some idea that you might think about using the mark on some type of goods or services down the line. You really want to make sure that those are things that are really things that you have a real intention to use, exposed to some idea that may not ultimately materialize. I touched upon this briefly before, but if it's a foreign application or registration, you don't need to prove use until 6 years after registration. So you don't have the burdens of that, but it's important to just understand that you will ultimately need to demonstrate use in order to maintain your registration. And in the US, unlike other jurisdictions, the goods and services must be specific to obtain a registration. So again, that's just very key to understand that, because you can't file for the entire NIS classification system and think you're going to get a registration in the United States. So again, just be very careful. So outside the US, generally speaking, there is no bona fide intention to use or requirement to prove use before you've secured your trademark registration. Of course, that does not mean that once you've gotten that registration that you don't have to prove use afterwards, because in most places you do, and I'll touch upon that a little bit later. Unlike the US, the first person to file gets the priority as opposed to the first person to use, unless, of course, the mark is well known. So it's really key to understand that outside of the US, with very few exceptions, no rights are developed until trademark registration is obtained. And even when it's obtained, and we can talk about that later, that doesn't mean that you have all rights to use the mark. In contrast with the US PTO practice, where your goods and services have to be specific, your description of goods and services can be broader generally, and sometimes you can file the whole NIS classification. So you can be a little broader. You can incorporate those things that you think might be related to what you're planning to offer in the next 5 years, or you could file a little more proactively for defensive reasons. So one thing, again, as we traverse this tricky world of international trademarks, it's really important not to assume things. Just don't think that because in the US you can file on standard character mark and get protection for different forms of the mark, that you can do that elsewhere, or that you can file in block letters. Well, that's block letters, but if you can file in black and white, and that'll give you protection for all color mark combinations. Because really, filing block letters may not protect all forms of the mark everywhere. Filing in black and white may not cover all color combinations. In fact, in the EU, we encourage clients to file in the colors that they plan to use the mark, because this is going to be important down the line after the 3 to 5 years when your mark becomes vulnerable to a non-use attack. A third party, a clever third party, could use this weakness or deficiency in your registrations in order to cancel them. The other thing is that even if you're not necessarily going to plan to register a mark or use a mark in Chinese characters or other characters, you might consider also making foreign language filings with those characters. Maybe in other Latin character jurisdictions as well, but I think more importantly, at least in China, think about Korea, potentially Russia, think about filing in those foreign language equivalents, and you can often consult with local counsel on this if your client has really not adopted that formalized Chinese character marks. And just important just to get there in order to get that registration, in order to block those pirates, but also enable you to have that ability to use your mark down the line. So now we're going to turn to trademark examination. So if you filed your application, what's next? Well, even here there's differences. Generally speaking, I would say almost every trademark office will examine the goods and services to see if they adhere to the classification system or local requirements. And that's important, right? Because you can have the NIS classification system, but there also may be separate local requirements to be aware of. So generally, the trademark offices will use the NIS classification system. So that will divide it into 45 classes. But not every country is using the latest version of the NIS classification system. So they may issue office actions as a result of that. It's also just important to know that you may have filed an application in the United States and it may fall into a particular class, or you may have filed an application in another country and it may have fallen into a certain class. And for certain classes, that trademark office may consider it not falling into that class, but going into another one. So you may have to move those goods or services, generally it's services, into another class. Also, in certain countries, they have subclasses. What does that mean? Well, when they're examining the trademark application, they may be looking for third-party rights. And if those third-party rights are in a different subclass, you may be able to secure a registration in that country, even though you're both in the same NIS class. Also, it's important to understand that in certain countries, it's still not allowed for service class registrations. So, again, this is something to bear in mind. You can't assume just because your country or the US has service classes that this is accepted everywhere. And it's also just, and this is another reason why it's important to keep up to date with trademark regulations around the world. The other one general rule, and I think this applies both to the US and internationally, once you filed your application for specific goods and services, you can't broaden them. So really just sort of think about what you want to cover. You can't be like, oh, I forgot to add socks when I filed for, t-shirts and jackets. Well, you'll probably have to file a second application for that. So just bear that in mind. So in addition to looking at the goods and services, trademark offices may examine on two other grounds, both absolute and or relative grounds. So absolute grounds of refusal can include that there's a failure to function as a trademark. It doesn't act as a source identifier. Or that your mark is merely descriptive. You might have another ground of refusal could be that it may be geographically deceptive. Maybe you include a certain town name in your mark, but you're not from there, etc. So generally speaking, when you have these absolute grounds of refusal, you'll want to come up with persuasive arguments and evidence to file with the examiner with the hope that the refusal is withdrawn. Most trademark offices around the world will examine on these absolute grounds. So as part of those arguments you want to present, you might want to demonstrate, well, argue simply that the mark does function as a trademark or that it's not descriptive, and you can give your various reasons why you think that's the case. If the mark has been registered elsewhere in other jurisdictions, the more the merrier, but that doesn't necessarily mean the trademark office is going to examine that, or accept that argument, but you could present that. And, as a last ditch effort, I would never go this route in the first instance, is you might want to submit evidence of use to prove acquired distinctiveness. But this is only if it's solely necessary, because you don't want to say that your mark wasn't distinctive to begin with, but that it acquired its rights, unless there's no other way forward with that. So the other ground that we had talked about is that they may want to examine on relative grounds. So, for example, but just know this is that some trademark offices do not have a citation practice. For example, in the European Union, they don't have, generally speaking, the EU member states do not have a citation practice. So it will be up to the trademark owner to have a very good watch service where they're monitoring the marks on the register in order to object. But there are a number of jurisdictions, including the US, who do cite prior trademarks um, as part of the examination process. And ways you want to overcome those refusals are arguing confusing similarity. Um, you might want to argue, consider canceling that prior registration for non-use if you can, but note in certain jurisdictions, the timing for the decision of a cancellation action may take longer than any sort of arguments and further examination by the trademark examiner. So you might want to just sort of consider ways of dealing with that. You can consider letters of consent. We discussed this previously, or I discussed this previously. Or what another way is maybe you can amend the goods and services. Maybe you can add a limitation. Maybe you can delete certain goods and services depending on your client's interests. So in terms of maintenance, so now we're going to sort of look at once you've gotten your trademark registration, what happens? Okay, so because again, there are differences between the United States and countries outside of the US. And I see a couple of questions, and I was thinking maybe what I could do is answer those questions after the presentation, if that works for everyone. So in the US, you'll need to file declarations of use periodically. So Section 8 of the Lanham Act requires the filing of a periodic declaration of use or excusable non-use to maintain a U.S. registration. The necessary declaration must be filed between the 5th and 6th anniversary of the registration, and which, with every 10-year renewal, meaning between the 9th and 10th years, the 19th and 20th years, etc., etc. You can file the declaration of use during a 6 months grace period and after the deadline with an additional fee. But it's just important to note that you will have to provide specimens of use, and there is, as I've mentioned, an audit program. So you just want to be careful that when you are presenting it, that the declarations of use are accurate, they identify the exact goods and services for which you've had use, and that you provide an appropriate specimen. You will also have to file a declaration of use for registrations if issued from U.S. extensions of protection of international registration. So you will need to do that as well. So IR extensions to the U.S. are not excused from this requirement. So it's important to know that terms vary by jurisdiction. Typically, it's 10 years, like the U.S., but there could be longer periods of time, so it's important to be aware of that. Internationally speaking, you really need to know what the requirements are by jurisdiction. Because in some jurisdictions, you may be required to submit a power of attorney. The power of attorney may simply need to be notarized, and that could be something that's pretty straightforward, or it may need to be legalized. And depending on the legalization, whether it's by apostille or by the consulate, it can take a long time, especially in the time of COVID. I'm realizing that in certain jurisdictions, especially, legalization can take quite a long time. So you want to get ahead of your deadlines and make sure that all your ducks are in a row. Some jurisdictions, you may need a declaration of use, similar to the United States, though they may not require a specimen. Some may do. Again, it's important to be aware of this and be aware of this ahead of time. And there may be, in terms of the declarations, just like with powers of attorney, there may be formalities. And if they have to be legalized, especially by consulates, that will take longer. So it's important to get ahead of that. If you have a trademark license recordal, which I'll touch upon briefly a little bit later, or customs recordals, then it may be important to renew those registrations early in order to then in turn renew the license or customs recordals. So In some instances, you can do that 6 months earlier. It might be a little longer than that, but it's just important to sort of make sure that you know what is tied to your particular registrations and that you renew everything in a timely way so it doesn't impact your various recordals. Renewals, I always want to sort of say to people, it's a good time to evaluate because, in the US, you have the declarations of use with the specimens, etc. But, in other jurisdictions, it may be a good time for you to sit down with your client to evaluate the current usage to see if it aligns with existing registrations. Maybe the law has sort of not necessarily changed, but been clarified in terms of filing and applications with black and white. Maybe that doesn't cover all forms of the mark. So maybe then you want to file some new applications which take into account color modifications in your logos. Or you may want to maybe have filed or started to use a different font. All of that stuff sort of should be evaluated at the time of renewal so that you can sort of think about whether you can modify existing registrations, because in some jurisdictions you can modify the marks in order to reflect the current form of the mark, though sometimes that comes with publication, so then it's open to third parties to sort of object, or where modifications are not permissible, then you might have to file additional trademark applications in that jurisdiction. So, in almost every country in the world, a mark must be used within a certain period of time after registration in order to be able to maintain that registration. That doesn't mean this is sort of separate and apart from filing a declaration of use, but if you don't use the mark within 3 to 5 years of registration in most countries, a third party can move to cancel your registration for non-use. Some countries have, such as like Honduras, which is in the minority, but you can file rehabilitation tax, which can maintain your registration. Some countries you may be able to file a declaration of excusable non-use. And certain countries like Chile, which have not had a use requirement to date, are actually considering implementing that into their newer law. So it may be that you have to keep track of this because in jurisdictions which might have modifications in the law when it comes to use requirements, you want to make sure that your client's rights are duly protected. So as I said, if you have no use, then it's not necessarily that your application or registration is going to be canceled by itself, but rather a third party can move to cancel your registration. And it's also important to note that like the levels of use or what is exactly needed for use to support the registration really varies. You can have certain modifications that are permissible under the local law. Some countries may require a significant amount of use in order to maintain the registration, or some countries may allow a token use as long as it seems genuine. So again, it really varies. The other thing to understand in terms of use requirements is that if you're going to use markings, whether it's a TM or the R in the circle, there could be serious consequences for improper usage of those markings. So be aware of that. Just be careful, especially if you're using your mark on social media. You just want to make sure that you have enough information to ensure that your client or you do not get in trouble. One other thing that I think is important is that you might not maintain, you should have an evidence file that maintains use evidence. Because sometimes if someone files a non-use cancellation action against you, you may not necessarily have a long period of time to gather that evidence. Or if you're operating in one country and the non-use action is filed in a different country, it's important to sort of make sure that they're maintaining evidence of use, which oftentimes invoices are important. The mere use on the internet may not be sufficient. So you want to just make sure that you have that evidence that could be easily gathered in the unlikely event, hopefully, that someone files a non-use action against you. So now let's talk about other types of recordation. I touched on this briefly, but in certain countries, you need to record your trademark licenses in order for either the use to inure to the benefit of the trademark owner. That is, if a licensee is using your mark and you're not actually using the mark in that particular jurisdiction, In certain countries, it's important that you've recorded that license to show that that licensee's use inures to your benefit. In some countries, you may need to record the license in order for the licensee to be able to enforce your trademark, if that's something you want them to do. Other jurisdictions, you may need to record the license in order to get the royalties out of that country. Particularly in the case of non-use cancellation actions or potential non-use cancellation actions, if a trademark owner has not recorded their mark and that particular in their jurisdiction requires license recordals, then their mark could be successfully canceled for non-use. It is important to understand that for license recordals, they can be expensive, they can be time consuming. Often they're tied to renewal terms, so that if you have a trademark renewal coming up, you may have to continuously renew that custom license recordal as well. And so again, you want to have a system that tracks all of that. And while in like the US and Canada, quality control is key. I always think that quality control is a key element of any license that you have, because you want to make sure that you're maintaining control of your trademark, which is one of the most important things that a company can have. Quality control is not necessarily needed in every license agreement or in documents that need to be recorded with the local trademark office. In addition to license recordals, if your client is shipping certain products outside of their core country, then you might want to think of customers portals as well. A number of countries allow for the recordation of intellectual property with customs authorities to prevent importation of counterfeit goods. The benefits include preventing fake or potentially harmful products. Think, for example, of counterfeit medicine, or car parts or other things. But also, like, fake brands are just damaging to most brand owners, because if you, for example, offer eyewear and someone has fake glasses out there and they're not of good quality and they break, the consumer may think that you're not offering a high quality product if they're not aware of the fact that the product is fake. So generally speaking, in terms of recording this custom or IP with the customs authorities, you'll need information on the trademarks and or copyrights, because sometimes you can record copyrights as well, depends on the jurisdiction. It's always helpful to provide as much information to customs authorities as possible, because the more information that you provide, the more health beneficial it is for the customs authorities when they're looking through various shipments to sort of seize the goods. So if you can provide photos of counterfeit goods versus authentic goods, or information on the authentic goods, for example, if you only manufacture in one country or a handful of countries, providing that information to the customs authorities can be quite helpful. If you have a list of authorized suppliers, they'll want that as well. If you might also want to provide examples of fake, products, or if you've encountered sort of past infringers or shipments from particular countries or etc., then you might want to put all that information in as well. A lot of brand owners will do presentations to the customs authorities if they can, either themselves or if they're dealing with customs authorities in other countries, they might want to have their local counsel do the presentation for them. But again, to make the customs authorities understand how to differentiate between fake products and authentic products, but you also want to make sure that in terms of those just general protections, that customs feels like it's supported. Or if you are dealing with goods and their particular like marketplaces or flea markets or other things that are known for counterfeit goods, having that information and providing that to the authorities may also be helpful, because then they can look to that and keep an eye out. For some bigger brand owners, they often sometimes will collaborate with other brand owners and again to sort of go after third party infringers. So that's something to sort of think about. But customs recordals are very key, especially if you have, to protect your mark from fake products being out in the marketplace. But just one thing to bear in mind is once your marks are recorded with customs, there's generally a very short response deadline. Sometimes you can get extensions of time, but it's also just important to know that there can be a very short deadline. So now, I touched about Paris Convention priority to begin with, but I think it's important because obviously not everyone has deep pockets. There are some international treaties that you can use to your advantage that are helpful. For example, you can use the Paris Convention. This provides famous mark protection, which I'll talk about a little later. You can use it to file Paris Convention priority applications. What does that mean? Well, if you file an application in a particular jurisdiction as the first filed application for that mark for those goods and services, then you'll give your client, that gives your client 6 months to file in other Paris Convention member states. So this is important for, say the client's launching a product in one country, then they can think about potentially filing in other countries, and it doesn't mean that they have to spend all the money at once. Rather, they can think about filing first in, say, the United States, and then filing in the EU within 6 months. So that gives them time to sort of think about their marketing plans. Another thing to sort of think about in terms of international treaties to get more bang for your buck, you can file an application before the European Intellectual Property Office, EUIPO. The mark is generally called an EUTM. It's one registration that covers all 27 member states. There are pluses, but there's sometimes some minuses because you have 27 countries, so there's more room potentially for people to object. But if no one objects to your application, then you can get a registration that covers all those instead of filing in each member state. If you want to file in Africa, I have to tell clients that Africa is becoming increasingly important for the trademark world. Think about a filing before the OAPI. It's one registration covering 17 African countries, but that might not necessarily cover all key jurisdictions in Africa, so just be mindful of that. And Madrid Protocol System, or the International Registration, which is a centralized system of international trademark registrations. There's also the Madrid. But in terms of Madrid, I'm going to talk about it a little more because I think it can be a tremendous cost savings for people. So the Madrid system is a one-stop solution to obtain and maintain trademark protection in multiple markets. It's convenient because you can file a single trademark application with your country of origin, and then you could file an international registration with the World Intellectual Property Organization and extend out that international registration to all the member states of Madrid protocol. It's in a single language, so it's English, French, or Spanish. You pay one fee in one currency in Swiss francs. You can obtain protection in multiple countries. What's great also, if you log on to Madrid Monitor, you can access real-time status of your international registration to figure out which offices have examined it, published it, if you've secured any, if there are any refusals relating to the same, or if it's been granted. All that is available online. And what's nice about it is it's unlike the EUTM where you have one single registration covering all 27 member states. It's actually you file as the equivalent of filing a bundle of national applications. So that is beneficial, certainly, and also it is a tremendous cost savings if you don't think you're going to encounter serious issues. So, as I said, there's substantial cost savings at the time of filing because you're not filing nationally. It's simple and quick. You're not going to have powers of attorney for the international registration. Depending on where you file, you may have to have a power of attorney when you file that base application, or for the IR, you're not going to need priority documents or translations. All of these are cost savings. You can claim Paris Convention priority Local counsel may not need to be retained unless you issues a refusal, though in certain countries, I do think it's worthwhile having local counsel appointed, such as Turkey and Australia and Canada, etc. So there may be select jurisdictions where you might still want to appoint local counsel in order to make sure that you don't miss anything. It's centralized, it's easy recordation of ownership and address changes against, because it's one system. You have a centralized renewal, and generally there's an 18th month rule, which means within 18 months without IR extension, the trademark office has to examine your applications. And this is helpful because there are certain jurisdictions, certainly around the world, where it could take significantly longer than 18 months in order to know the status of your application or registration. So there are some disadvantages as well to Madrid, which is it's subject to central attack for 5 years. So if the underlying application or registration becomes invalid, then you will have to file subsequent, you'll have to transform those extensions of the international registration into national filings, which will incur additional costs. And the thing is, the scope of goods and services cannot be broader than the basic application or registration. So, for example, if you're a US company and you're filing an international registration and the international registration is extended out, you're going to have to file the application based on proposed use, or it'll be narrower than, for example, if you were to file in the EU, where you can file a bit broader. So again, if you want to file broader for defensive reasons, Madrid may not be the system for you. The other problem is, if you file and you're not getting opinions from firm counsel on whether the mark is registrable, or if you haven't done full searches in other countries, then, again, you may face problems that you're not anticipating and may be additional expenses for your clients down the line. You can't amend the mark. As I said, in certain jurisdictions, you can amend the mark later. For Madrid, you cannot do that. And there's still a number of Latin American and Middle East countries that are not members, so you're still going to have to file locally in those jurisdictions. So now we're going to turn to enforcing your rights. So as trademark practitioners, we know if you don't enforce your rights, you essentially lose them. So it's really key for me, just as important as filing an application or registration in a particular country, it's really key that brand owners and we as outside lawyers emphasize to clients the significance enforcing their rights. Because if you get a registration and you don't pursue third party, whether infringers, whether they're innocent or not, you really could lose your rights. And examples of certain brands that have lost their rights because they didn't enforce or there was widespread usage are, these are US examples: aspirin, escalator, cellophane, thermos, Pilates. Of course, there could be still some registrations for these marks in other jurisdictions, because as we know, as we traverse through the universe of international rights, standards are not necessarily the same. So some of these marks, some of these terms may still be considered marks in other jurisdictions. So one thing I've always think is really key for brand owners is to think about demand letters. Because demand letters have gotten a lot of more press more recently, and I think these are important considerations to make. First of all, think about priority. Who has earlier rights? If you're dealing with a multi-country dispute, and say you have rights in the US, and you may have rights in a couple of other countries, and you operate in your company that operates in multiple jurisdictions, the other company may have rights in other jurisdictions. So is that an instance where you really want to sort of flex and enforce your rights against them? Also, you may have use, but they might have registration elsewhere. So it's important to sort of think about that. It's also important to think about just sort of timing, sort of generally, and also the nature of their rights. Because, for example, in the US, you can file Section 15, attesting to your mark being incontestable, i.e. that There are no pending disputes against your registration, in which case, if your mark becomes incontestable, it may be difficult to challenge that third party's mark based on your prior rights. The other thing to sort of think about in terms of timing is if you do send a demand letter, is there a deadline by which you need to file a court action, or will you be prevented from either A, pursuing the court action, or B, whether by sending the letter you triggering this deadline, whether it means that if you don't file an action by a certain date, whether you'll be barred from filing for a preliminary injunction or securing certain types of damages. So it's really important to understand, especially in the international context, if you're going to send a letter, understanding what rights and who has priority, but it's also important to understand that once you send that demand letter, it might trigger certain deadlines and you may be preventing from enforcing the rights down the line. Also, when you're thinking about demand letters, is it going to be something is it money saved in the sense that are you sending the letter and if the other side complies, that's great. You might not have to file litigation against them or file an opposition against them. But it may be, some jurisdictions, certain local councils advised me in the past that it's not worthwhile filing a demand letter if I'm going to file an opposition because the third parties generally don't respond favorably to those letters or they ignore them. So maybe it might be better to think about sending that demand letter after you get an opposition decision or after you get a cancellation decision. But again, you want to be aware of any deadlines that you're dealing with. In certain jurisdictions, if you, like in the UK, for example, if you send a demand letter and you claim infringement of certain products and you don't have registration, the other side could sue you for groundless threats. So, or the other side could go in and get a declaratory judgment of non-infringement. So it's just sort of important to understand like the risks of sending letters, especially, I never send letters as a US attorney to someone, say in the UK or anywhere else, unless I'm working with local counsel because it is quite tricky. I think the other thing that's been really there's been some press about it is the tone of, or the approach or how you approach a third party in a demand letter. Oftentimes as lawyers, we want to send these firm letters telling people they're infringing our rights and they better stop or there's going to be serious repercussions. Well, maybe that's not necessarily the best way of doing it. Maybe it's better in instance if it's a client and they have some relationship with the third party. Maybe it's better for you to draft a appropriately toned letter and then the client sends it themselves. If you're a big company and you're writing to an individual or a smaller company, there could be PR risks, right? People often go to Twitter or Instagram or maybe even TikTok, at this point, and if they get a demand letter and you might get bad press from it. Maybe you don't care about it, but maybe your company does care, especially when it comes to like smaller businesses and depending on who the business owners. So you really want to think about the ramifications of the letters that you're sort of sending. It's also important to tone, again, you may not necessarily want a firm letter. Maybe, especially in this pandemic, you want to explain to them you understand the pandemic's going on, maybe they need more time. So just be careful about demand letters. So enforcement, there's different types of enforcement procedures. There are administrative actions, fall into one sort of category. Oppositions are generally administrative actions because you're filing them before the relevant trademark office. Certain countries, cancellation or invalidation actions are administrative actions. In some countries, they're not. But again, these are dealing with the registration or the filing of a trademark application. Court actions, court actions are typically aimed at stopping use of a mark unless a cancellation action has to be filed before the court. There are anti-counterfeiting actions that you can take. Again, depending on the jurisdiction, that may be something that's administrative or not. I'm not really going to go into anti-counterfeiting actions right now, but I just wanted to list them as a type of enforcement procedures. Similarly, like if there's an infringing domain name, you might be able to sometimes bring that in as part of your court action. Sometimes you might have to file a separate action. But as with anti-counterfeiting, I'm not really going to go into that at this point. So, oppositions, they're aimed at preventing a registration, except, as I always said, there's always exceptions to everything. In certain countries, you file the opposition after registration. A mark is registered. So there's post-registration opposition procedures. Generally speaking, oppositions are filed before the trademark office. The grounds of objection can include the obvious, prior applications or registrations. It could be based on the mark being non-distinctive, but you want to be careful because if you're going after a third-party mark that you think is similar to yours, you probably don't want to say that their mark is not distinctive because then the implication would be that your mark is not distinctive and you shouldn't have gotten that prior registration. So again, be careful what you argue. You can rely on fame or reputation where there's no application or registration for similar or identical goods or services um, based on Article 6 bis of the Paris Convention or the TRIPS agreement. But such oppositions tend to be really evidence heavy because you're going to have to show that you have a reputation. So it's important to understand that. You can have trade name rights in certain countries. So some countries require you to actually have a business operating under that trade name. In other countries, you don't necessarily. Um, or you could, some countries even rely on copyright. So it's important to understand that as well. So cancellation actions are available after registrations generally. Some countries it's administrative, other jurisdictions they can be filed before the court. It's important to understand if you don't go after opposition or you don't file an opposition, a cancellation action will generally be more expensive than that. They're generally the same grounds of objection, but those could vary. So again, be mindful of that. So here are some examples that are a little different. As I said, you have very similar grounds of objection. So you have non-use. Well, ones that are different include non-use, but you can file based on prior registered rights, fame, reputation, well-known status, bad faith, prior trade name rights, non-distinctiveness, copyright, etc. So just a quick point. In some countries, there's a distinction between a revocation action and an invalidation or cancellation action. A revocation action typically deals with like non-use actions because it's cancellation effective from the date the action is accepted, whereas an invalidity action basically claims that the mark should have never been accepted in the first place. All right, so when you're advising your clients about oppositions, cancellation actions, really just be careful of a couple of things. Costs can be awarded to losing parties. For example, in Hong Kong, costs can be very expensive. So just bear that in mind and be careful that you're not filing something which ends up costing your client thousands of dollars if they lose. Also, be mindful of when evidence is due. Some offices require the evidence to be due all filed by the opposition deadline, which means you're going to scramble quite a bit. Some evidence is due after the opposition deadline. You may have like a month, two, maybe even have like a year or more. Some jurisdictions, such as the EU, have so-called cooling off period, where it's encouraging the parties to negotiate with each other favorably in order to resolve the matter amicably before you go into the adversarial phase. So you may have some time, but of course, it's important to understand also the requirements. Also know in certain countries that if you have a mark that's older than the 3 to 5 years period, depending on when the mark becomes vulnerable to non-use, that an applicant can require proof of use during the proceeding. And if, for example, in the EU, if you're unable to provide use and your mark is older than 5 years, the opposition can automatically fail. So be careful of that. Other things to think about is that in some countries, not everywhere, and this is like maybe a limited number of countries, it may be better to consider a cancellation action rather than an opposition because maybe the entity that examines cancellation actions is more sophisticated. So think about that. But again, there are also drawbacks to doing that, including the fact that the other side will have registration. So, in terms of actions based on prior applications or registrations, this is really straightforward. Though if you're relying on a prior application, and maybe the action may be suspended until you secure a registration. In terms of, yeah, non-use, we've talked about a lot. So I'm not going to go into that because I realize that I'm going to be running out of time if I go through everything. So one thing to note is if you're filing an opposition, that's not going to stop the other side. And if you didn't send a letter, then you might want to consider a court action. You could rely on trademark infringement, passing off, or unfair competition. Passing off is essentially unfair competition in common law jurisdictions such as the UK. You could rely on prior trade name rights. You might be able to rely on copyright infringement. But again, these are different grounds of objection for that. Just if you are going to file, am I running out of time?
No,
Uh,
no, no, you're good. You still
okay,
you still have you still have time.
okay.
Um,
Oh, the
but
CLE code. Yes,
it's
sorry, I'm
time.
pausing
Yeah,
for
it's time
that.
for the CLE code. And then you'll have about 10 minutes or so after. All right, everybody, here we go. CLE code is the number 4, the word abroad, not 2 words, a broad, but rather abroad as in not in this country, and the number 1. So again, that is the number 4, the word abroad, the number 1. All right. Thank you. Please continue, Lydia.
All right, great. Thanks, Bree. So I just want to talk about quickly some drawbacks, right? So first, if you have multi-country disputes, you have to think about strategically in terms of court actions because maybe you want to pick and choose a jurisdiction where you're going to get the fastest decision. But if you want to stop use in all the jurisdictions, unless you can settle with the parties amicably, you may have to file multiple court actions. And in considering where to file court actions, you want to think about where you're going to get the most bang for your buck. So if it's a jurisdiction where you have a decision will issue relatively quickly, you might want to file there as opposed to a jurisdiction which may take years and years and years for a decision to be rendered. So it's important to think about that. In terms of court actions, it also can be very expensive to file a court action. Most countries are not like the US though, because the US is really expensive. So, again, you want to think about budget for your client as well. One thing to bear in mind, comparing the US to other countries, not only in terms of cost, but one of the reasons why the US can be so expensive is that the US has discovery. And most countries outside of the US don't really have discovery. So people are not going to ask you all the different interrogatories and other questions like that. So just bear that in mind. So yeah, I mean, I sort of briefly in terms of anti-counterfeiting actions, said I was really going to go into this, but you want to stop the goods from coming in. Um, in certain countries it could be a court action if you have to file it, which can be expensive, especially if you have a seizure that's only for a couple of items. So your client is going to have to weigh that very carefully. Um, you can have different types of penalties. The standard one, of course, being this destruction of the goods so it doesn't enter into the marketplace. But maybe you can get fines, or if it's a huge seizure, then consider potential imprisonment. So I wanted to sort of focus the final part of this talk on well-known marks and bad faith. And again, we're going back to my favorite, which is the Paris Convention. So, and then you also have the WTO's agreement on trade-related aspects of intellectual property rights, also known as TRIPS, which expanded the Paris Convention. And I think the Paris Convention is an important tool to have in your back pocket, especially for those countries that are members of the Paris Convention. But before I go into it, I just want to point one thing out in terms of the Paris Convention. So just because a country is in, uh, just because a country is a member of the Paris Convention, it doesn't mean that necessarily every country is going to accept famous and well-known mark arguments. Right. And the other thing to sort of bear in mind is while the Paris Convention talks about well-known trademarks, the terminology that's used by different trademark offices around the world really varies. You can have, for example, in China, you could have like a certain reputation, which isn't a well-known mark, but then you can have a, another sort of additional status as your mark gets more famous. So in terms of, but now going back to the Paris Convention, Article 6 bis is key. Always put that in there when you're writing to your foreign counsel because it affords protection for well-known marks, irrespective of whether they're registered or not. So, I always, if the client doesn't have rights in a particular country, then I will say to them, can we rely on the Paris Convention? Because really, member countries are supposed to provide a way to refuse or cancel registration to prevent an authorized party from using identical or similar goods when used. Use of such goods will cause confusion. So it's important to mention that. Article 8 of the Paris Convention provides trade names, whether protection for trade names, whether they're registered or not. Again, it's always worthwhile raising that when you're communicating with people outside of the U.S. And then Article 10 prohibits unfair competition. So in terms of TRIPS, though, it expanded the protection of Article 6 bis, because as we said and saw in the earlier slide, Article 6 bis was focused on goods, but it extended it to cover services. It provides members shall take into account that a mark is well known in the relevant sector, not as a country as a whole. And this can be really important because what if you have a product or service that's well known to the group of people who take advantage, purchase, or use those services, right? If you're required to prove use for the population as a whole, it may be a more difficult thing to do as opposed to in the relevant sector. So I think that was an important enhancement of it. Also, Article 16.3 extends protection to goods or services which are not similar to those for which the trademark is registered, provided that the use of the trademark for those goods and services um, will damage the interests of the registered trademark owner's rights. So just know level of scope of protection varies by jurisdictions, as I said, but it's always worthwhile to throw in the Paris Convention and TRIPS where you can. Um, in certain jurisdictions, you can apply for well-known status separately and apart from a pending action, or you can claim it as part of the pending action. So look at where that is, especially if you're representing owners of well-known trademarks. You will have to provide lots of evidence and the extent of use in the country and possibly elsewhere. So you're going to have to provide a lot of evidence. And here are some examples of some evidence. So that you'll want to provide: first use date, geographic evidence on where the trademark has been used. In almost every country, it's really important to the extent that you can gather evidence of use within that particular country. Do that because that's going to be the most important. If you don't have that, look at the neighboring countries and look at the world as a whole. Want to know how long it's been used there, how much market share is attributed to that particular trademark. Do you have sales figures within that country? How about outside that country? It's actually really interesting. Just recently, we got a FAME decision in the EU for a client, and we didn't even provide any sales or advertising information, and they still accepted the mark as well known because we were able to show through other means that the mark had acquired a certain reputation in the EU. You want to know the nature and promotion of the trademark. With social media, these figures may be, you want to throw those in, as well as any sort of web hits that you might get, etc. If the media is referred to the mark, if they've referred to the mark as a famous or iconic or anything like that, that's going to be really helpful. You want to show the relevant channels of trade and sort of like, because again, if you want to show a reputation within the relevant sector, you want to then you want to show what that sector is so that the trademark office or the court can examine that. But really, when you're trying to prove reputation, it's really key to demonstrate the reputation across the board in the country and outside of the country. And with that, I was going to talk about bad faith, but just know that there's lots of examples of bad faith, that you can also put in, especially if you're a well-known trademark, if they try to sell it to you, etc. So that's another argument to raise if you're enforcement actions. And that's it. So thank you all for listening to me, and I know there's some questions.
I know there are, but unfortunately we are out of time. So, Lydia, I would, love it if you would be willing to answer questions that people asked you through Brella or other things like that. If you want to schedule a one-on-one meeting with Lydia, she could maybe give you a little bit of time. We absolutely appreciate this presentation. It was incredibly enlightening. And I know everybody, I think there was definitely a point when the chat went silent because people were too busy just writing down every single thing you said. So we really, really appreciate that. After this, we have a break for about 20 minutes. Our next session is From Handshakes to Elbow Bumps, Tools, Tips, and Technology for Winning New Business in the hashtag New Normal. So have a quick lunch, take a quick break. I will see you here in the stream tab at 1:20 Eastern Time. Thank you so very much for joining us, and thank you, Lydia, for this wonderful presentation.
Thank you, everyone. Sorry I went over.
No, I think this is a topic that you could absolutely talk about forever and just
Okay,
never exhaust it. So thank you
exactly.
so very much.
Take care. Bye.
Bye, everybody.